Hello, Will. How are you doing today?
How's it going, LJ? It's been a busy week, but I'm excited to be here and talking about probably the most exciting development since I can remember in immigration.
That's right. We've been holding off for almost 2 weeks now, if memory serves me right. But to begin with, I'd like to acknowledge that I'm in the traditional lands of the Muwekma, Miwok, and Yokuts in the San Joaquin Valley.
And I'm speaking today from the unceded traditional and ancestral territories of the Musqueam, Squamish, Tsleil-Waututh, and Kaikat nations here in Burnaby, British Columbia.
All right. For starters, Will, what are we talking about today?
It's not a wind, it's not a fish, it is Chinook. And what we know about Chinook is it's IRCC's secret pet project that they've been working on for a couple of years now to process temporary resident applications. They've kept quite a lid on it for a while, but now through litigation, they're starting to open the doors and show what goes on behind the scenes. So today we wanted to bring on someone to talk about it.
That's right. And we do have a special guest today, and she has been doing a lot of judicial reviews and challenged more study permit refusals than we have likely done together, Will, combined. She has focused her practice area on helping the Iranian community, as I understand it, and she's holding into account the Ankara visa office.
Yeah, and she happens to be, for me, the initiator of the Chinook issue. So what happened a while back was we had been engaging on Twitter, and then I get an email from Zeynab saying, you have to see this. I've learned something that people don't know, and we need to talk about it. And it turned out to be an affidavit, not the one that's currently in this case that we're going to talk about, Okrin, but a previous iteration of the affidavit, very similar. And they pretty much laid out Chinook. And that's when Zeynab and I first learned about Chinook. And that's why we have her on as a guest, because she's the one who has thought about it probably more than anyone in Canada, I would say.
And without further ado, we'd like to welcome Zeynab in.
So without further ado, I'd like to introduce our friend and friend of the show, superstar lawyer, Zeynab Ziaie. How are you doing today, Zeynab?
Hi, Will. Hi, Lou. I'm great. How are you guys doing?
Wonderful. We're so excited to have you on the show today to talk about Chinook. I was just telling our audience about how we started collaborating, and I think even LJ didn't know some of the details, so we're excited to talk about it all today.
I'm looking forward to it. I think this is an interesting time, and we'll have to see how this progresses, especially since the hearing is coming up in about 2 weeks.
Absolutely. And we're talking about the federal court case of Okrin that's occurring in 2 weeks. And Zeynab has some exclusive to drop on today's episode as well. So let's talk about first, in our show, we tend to like to introduce our guests and give a little bit of a background. And in this case, it's life before Chinook. So tell me a bit about your practice and how you started handling this volume of study permit refusals that got you to learn about Chinook.
Sure, absolutely. So based on language ability, I have worked predominantly with Iranians and Iranian Canadian applicants for the past decade, working in all kinds of different economic classes. And also in the last 5-6 years, as the policies of IRCC have changed, allowing for more temporary applicants, across the world, really, that has opened up an opportunity for more and more students, particularly from Iran, to apply. And historically, actually, Iranians are one of the top source countries for immigrants, skilled immigrants to Canada. So before Chinook, I'm assuming Chinook probably came in to practice, into use in the way it is right now, probably from late 2019. And we definitely know that it's been around in 2020. But before that, what we would see in, for example, the local visa office where the study permits were being processed, which is Ankara, if it was possible for an application to be refused. And what if it was a complete application, what we could do is actually reach out to a real person, often the program manager. We would explain, for example, they said this application has been refused for lack of funds, but these documents were provided in the application. And those would be our informal requests for reconsideration. And we would get responses, like there was an actual person who would review and respond. And a lot of times they were extremely reasonable. I understand as volumes of work went up, this whole Chinook system has come into play. And also should add, in cases where files were in fact deficient and somebody came to us, we would advise, reapply with a very complete application, and almost always you would get very different results when the application was in fact complete. Fast forward, what we're seeing in 2020, 2021 is that, sure, volumes have significantly increased, but a lot of decisions that are being made have no relationship to the underlying cases that applicants are submitting. And I'm sure, again, it's because of the sheer volume of files that they're facing. Requests for reconsideration are not receiving responses, or are just receiving the standard similar response that the decision is what it is. And the challenge also is, there's been a lot of reconfiguration of where files are processed. So a lot of actually applicants, in our case, from Iran, are actually processed in the Ottawa visa office. So there has been that kind of reallocation of files. So we're seeing decisions coming from Ottawa for a lot of these applications.
Mm-hmm. So what you're documenting is possibly due to the volume, a change in the way immigration is handling study permit applications. I want to maybe frame this also in your understanding of Vavilov. And I know many of our cases don't make it to litigation because they consent earlier, or we don't get a chance to go to the court and argue Vavilov as much. But how did Vavilov change the landscape? And do you think it's a case that we should be thinking about as we talk about Chinook?
Well, I actually do think it's very important. I use that case in every single application for judicial review that we're putting forward, because it is about the opportunity to really have reasons that are justifiable and are that decisions are based on the documents and the evidence that were before the officer. And I think that the challenge that we're facing is a lot of applicants would have, in the prior system, as I just explained, been able to reapply with more complete applications, or would have reapplied and an officer would have noticed the error in the first refusal. But what's happening now is that if you have a refusal, you're just going to almost automatically get refused again. I think it becomes one of those factors that gets plugged into something that gives them a chance of highly refusing your application. Not always, but very, very likely. And that's why applicants, I think, have turned to judicial review. And this is where we are therefore able to use case law such as Vavilov to really to make those arguments. And there have been some really positive, I think, decisions that have come out of the federal court in 2020 and 2021 that are specifically study permit applications. Generally speaking, the court has always adopted, lower procedural fairness requirements for temporary resident applications. We all know that, and we acknowledge that, and we're not expecting the same level of review as an application for permanent residence, for example, or citizenship. But there has to be a minimum. There has to be some correlation between the evidence and the reasons that we're seeing for refusal. Mm-hmm. And that, because I think there's just such sheer volume of applications that they can't process all of them accurately, we're seeing so many refusals of worthy applications. And so, we are definitely able to use Vavilov, and that does come into play. And that's why I think a lot of actually cases will settle. I mean, I know we're going to get into that, but it's an important decision that is actually opened the door for us to do these kinds of judicial review applications.
Yeah, and as a follow-up to Will's question, I'm wondering two questions really. What trends did you see when you were looking at Okran and in light of Vavilov? And as a follow-up, actually, just out of your historical involvement in this, how did you first find out about Chinook?
Okay, that's a really good question. So, we started doing a lot of these applications in early 2020. And the trend that we saw was that, I will tell you, I have reviewed several hundred refusals during this period of time. And we have not applied for judicial review in even half of those cases, because oftentimes applicants will not know, will have made mistakes, will have created incomplete files, and they're just not appropriate for judicial review. We would say the decisions are in fact reasonable, right? It's the cases where the decisions are unreasonable that we're taking these steps. So my experience, for example, in early 2020 was when we were filing these applications for judicial review, the Department of Justice lawyers would come back much more quickly with an offer for settlement because they, it was probably the first time. And I tell my clients this, I'm like, when you file an application for judicial review, it's quite possibly the first time that somebody will actually review your file and read your full documents, right? Because the visa officers don't have the time. And there's an irony there, right? Because I'm sure the cost of a visa officer is much, much, much lower than a Department of Justice lawyer, right? And the costs that are associated with litigation. But what we saw was that there was a lot more willingness on the part of DOJ to recognize that there were these errors. As we moved forward, I think that this has probably changed a bit for various reasons. And I think the first time I saw reference to this particular affidavit that we're talking about here was actually in a different case called Zahra, Shafakat Zahra, I think. And that case was, they filed this affidavit in April. So Department of Justice filed the affidavit regarding the Chinook system in April 2020. And shortly thereafter, they filed a letter in one of our applications saying that in an independent matter, we filed this, we want the court to know. And so, obviously I requested a copy and I read it and I thought it was really strange because I thought it was setting out something that was not in the best interest of DOJ to actually disclose. It was telling us that they're possibly not disclosing everything. It was also telling us that they have this extra system that they're using to move data over, move it back. And I was kind of concerned. And then I saw it again on another matter. And that's when I was like, I think we need to look into this. And I had seen some of Will's writing and texts with regards to international students. So I reached out to him. It ended up that matter settled, but they switched this all over to the current case, which is Okran, and they filed the affidavit in that case. And in this case, it hasn't settled. The hearing is scheduled to take place in 2 weeks. And so there was an opportunity for us to reach out to, I think Will actually took the initiative on that, reach out to counsel who's working on that application. And, we've sort of tried to provide assistance. They've been able to do cross-examination on the affidavit, which has brought to light some interesting information, but there's still a lot of question marks. I mean, sure, we know a little bit about what's inside the black box, but I think there's still a lot for us to figure out.
I definitely agree that this whole episode has actually brought about more questions than answers. And this allows me to shift the conversation a little bit to the technical affidavit and to what we've gleaned so far. But what were your first thoughts regarding the, the system when you first read the technical affidavit?
I as I said, I thought it actually was counterproductive for DOJ to be putting this forward. I wasn't sure where they were going with it. And I actually was quite surprised because I had never we don't really know how visa officers make the decisions. We have some information that we've been able to get from access to information, some manuals, etc. But we don't really know what happens in what order, they've never officially come out. I don't think we don't have any data of how much time they spend processing applications. We know that they have a lot of applications. So it was very interesting to see this. It's literally like a homemade tool, I would say. They've created an Excel sheet. I mean, I can go into a little bit of detail if you'd like, if it's appropriate. So it's what it is. From what we've been told through this affidavit is that it's an Excel tool. It allows the officers to pull all the information, some information from the GCMS system. And from the examples they provided, it's information like name, age, place of birth, city citizenship, country of residence, really basic information. And it then allows the officer to not have to go back into GCMS. And the affidavit says that the officers still have access to the documents in the file, but it doesn't tell us does it record it if they access the documents? Do they have to make any particular notes? There's nothing there. And the idea is that within the spreadsheet, they can pull 100 files at the same time, and each file will be one row. And therefore, the officer can just go across the rows, and then they'll get to a point where they're like, I want to accept or refuse this file. And they just make a note. If they want to accept it, it's an acceptance. If they want to refuse it, they put, refused, then there's a pop-up, which is, I think, the most interesting part of our whole conversation. I like, when I think about the system, I think about this part, which is there's a pop-up, which is their notes generator. And in this note generator, the officers are given, from what's been described in the, in the affidavit and what came out in the cross-examination, a whole series of potential reasons, literally, that they can choose, and they can select this, and that those can become the notes. Now, apparently it's possible for an officer to add extra things into those notes. From my experience, as I said, I've seen so many refusals. They do occasionally add in an extra couple of words here and there, but so many of these read exactly the same. And what happens after they generate these notes is that they copy and paste them. So they'll do like maybe 50, maybe 100 different people at the same time. And then they can just copy and paste the final notes back into GCMS. There is an extra column in there for their working notes. So, if they're reminders to themselves, we don't really know what those working notes are. Maybe an officer writes, need to check bank statements, but we will never know that, because those working notes are not copied over. And that is like the main part of this Excel spreadsheet. And the other challenge of this is, because they're putting so many different applications into one spreadsheet at a time, they claim that there's privacy concerns and they cannot save these spreadsheets, right? So they'll say, well, if we want to save this, we'll have to go back, redact like the other 99 if we want to give one person their spreadsheet. And so we don't want to put this out there. And so they don't actually save it. So those spreadsheets and the working notes are completely deleted. And all we end up with is some notes that are copied potentially correctly back into the GCMS system.
So moving just one step back here, we do know for this Chinook system, there are also different modules. There's module 1, file management, module 2, pre-assessment, module 3, decision maker, module 4, the post-decision, as you were talking about, and then module 5 with our indicator management. What's interesting as well, and I think, Zeynab, we found out a lot of this through the cross-examination process, is they're not applying all these modules across all visa offices. And in fact, the version of Chinook they're using is not even the same among the different visa offices. So does it give concern to you that there is really no oversight, legal oversight or what be it, and that different visa offices can choose what they want to do with this tool?
And can I chime in a little bit just to add to Will's question, is that are we ending up with really uneven decision-making processes?
That's a really good question. But Lou, I would say we probably already have uneven decision processing across the world, unfortunately. And I think because we, between at least the three of us, and probably a lot of your listeners will know this too, deal with different parts of the world, we know there's uneven decision-making for sure. And I think this adds to it, right? Having different versions of the system, having different combinations that are being used. So, I think it's module 2, which is the pre-assessment in some places. And I believe they use the example of India, but I'm not quite sure.
Southeast Asia, I think, was that
yes,
one.
I think so too.
Yeah, module 1, sorry for cutting off. Module 1 was sub-Saharan African, Latin American, and Caribbean. Module 2 was Southeast Asia. And then module 3 apparently is being used by most. So, but these countries, these areas obviously are regions where we're seeing high refusal rates. So I thought that would be...
And I think that's really, really interesting because, for example, this module 2 that they have is a pre-assessment. So what they described is that the local staff will do a run through of each application. They're not the decision maker. They will do some sort of summary of the file or some summary notes and put it in. And so that really raised questions for me in terms of accountability and, how does that get checked? What if that person who's pre-assessing made mistakes and the decision maker only relies on those notes? Like we have no way of checking that, to verify that. And it's not used across the board. So again, uneven decisions for sure are definitely going to be resulting from this.
Yeah, and if I can jump in again, I've seen refusals where Essentially, the pre-assessment is done out of Hanoi, and then the final decision is actually done out of Singapore or Manila. So it's interesting because like these pre-assessment, these program assistants are essentially coming in from different contexts. Sure, you can reduce, categorical issues such as age or gender or citizenship, but then when we're starting to talk about the subjective elements of, let's say, the push and pull ties analysis, then it becomes a problem.
Yeah.
Mm-hmm.
Yeah.
And to Zeynab's point earlier, actually, really interesting when you said to think something about copy paste. I'd like to show you something in today's episode. We've shown it to you before the show. I'd like to refer you to that excerpt of a GCMS refusal note. And we're showing it to our viewers on YouTube. But basically, for our listeners on the podcast, the audio version of this is that what these notes say at the top of it is select as applicable. And then there's a list of essentially grounds for refusal. And then there are ending notes essentially that cap off on how this application is being decided on. What are your thoughts, Zeynab?
I think that's fascinating. It's one of those slip ups where you get to see a little bit of what potentially that note generated looks like. But again, I'm not surprised because this is literally what we're saying. And unfortunately, it used to be that only when you got your reasons on TRVs, visitor visas, work permits, and you had the very standard language, which was the refusal, standard like 2 or 3 bullet points that they would select, that was template. But now the notes are becoming templates, right? Because they're selecting from here. Now, to be honest, in terms of expediency and those interests of efficiency, et cetera, I think that there could be a way in which this could be done potentially, where even the template notes, there's more nuance to them, and they could actually address the points that are relevant to the case. What we're seeing is they're completely irrelevant. So for example, there will be an applicant who's married, fully established, has children, and they're applying for study permit by themselves. And the decision notes come back and say, it's refused for family ties, and then says applicant is married or has dependents, but I'm not convinced. And there's no context, there's no explanation. It just does not match up. Or, people who have valid visitor visas and they're refused on a study permit, and it's the purpose of trip because we don't think you're actually going to come study. And the notes don't address the visitor visa at all, for example. And, if the person really didn't want to come and study, why would they apply for a study permit? They already have a visitor visa. So it's these kinds of situations where, to be honest, even with this whole discussion that we're having around Chinook, I think the reason our applications in federal court are either settling or they're actually usually quite successful when they do go to hearing is because there is such a disconnect between the officer's reasons and the evidence that's presented by the applicants.
So I guess my question though is, would it make more sense for immigration to be pursuing the route that they're doing now by coming up with, let's say, an answer key? And I know in the cross-examination, they said they could have up to 100 different reasons for refusal. Wouldn't it make more sense for them to create a very, very detailed answer key to refuse rather than allow officers who themselves may not have the training or experience to make findings, then have to show all their notes and then have to produce? Because we've seen when that happens, then they start making the mistakes that are also easy to judicial review, right? You see the use of some things like, modest finances, they meet it, but they're modest things that, we go to court and you say, well, that's not the legal test. Or if they make commentary on someone's immigration status and you're like, well, that's not the legal test. If they create a good enough answer key, that could be the legal test, no?
Well, here, I think there's 2 parts to this, in my opinion. One is, I think we owe even our, the temporary applicants a real duty of fairness to assess their applications. And I think part of that is we have to train our visa officers, right? Like we're charging $150. We being Canada, right? IRCC is charging $150 per application. That adds up over the volume of files they're doing. And alternatively, given how much money students have to spend in order to prepare their applications, submit them, all of those things, if they increase the application fees, even doubled it, I don't think it would have a significant impact on the number of applications or access for people to try and apply, but that budget could be used to better train the visa officers, right? I think that is, if I was going to suggest something, I would say, let's go down that route, because that makes it a fairer system. But the other side, I think, if they're actually coupled with the training, there was an opportunity for them to really go through and provide much more accurate reasons in some kind of, answer key, as you mentioned, that has a lot more options that could be fitted to that, the particulars of that case, then I think that makes sense. One of my own concerns that I always have is I don't think officers have time. They didn't answer this question on cross-examination. They tried to get some information from the deponent on this, like how much time does an officer have, or how many files are they expected to get through, and they kind of said, oh, we can't really answer that and we don't have information. But I'm always concerned. I don't think officers are really afforded any reasonable period of time to review a file. Like, honestly, I don't think they even have 5 minutes per file. Yeah. And 5 minutes per file is nothing when you really think about like what I'm sure you guys do the same thing. When we put these applications together, it's like potentially 100 pages, right? For a study permit. There's detailed information, there's documents, we describe them, we have submission letters, we have study plans, there's all kinds of documentation in there. And, there has to be, I think, a balance between efficiency and providing a fairer opportunity for people to really have their files assessed.
Yeah. And we know from reading Vic Sashowich that I think it's minutes that they have to review. So it's not uncommon that when you represent a client to find out that the information that immigration says they didn't provide, or a fact that they say is not there, is actually in one of the letters. But that actually brings me to the last question I wanted to ask before we turn it over to the litigation and how, as counsel, we can participate moving forward on Okrin and on Chinook. What do you think that applicants should do now, right? Because when it comes down to it, now that immigration is barely extracting information from an application. A lot of it looks like from the Excel tool they use, auto-generated from the forms or auto-fed. A lot of the nuanced details that are in our 100-page, materials are going to be missed. That is just the reality of the system. So what should applicants do to try and beat Chinook or catch the Chinook, so to speak?
Okay. I think there's two different approaches that I take to this, right? So what we know is that data is being pulled from the main forms, like those forms that you have to validate before you submit. So they're probably the easiest ones that are getting pulled into the system. So answering those questions as accurately and as completely as possible. And I know it's challenging because there's only so much information that's asked in the main application form, but making sure that it's accurate, provide in the description of activities, providing a little bit more information, like not just employed, not just student, but providing some information in there. I think that's really the only thing people can do on their form side. But what I'm advising everyone that we, ask about study permits that we represent ourselves, we're taking all of that experience that we have from the judicial review work to make the files as complete as possible, right? With a view that hopefully an officer will review this, but if they don't, and this file is going before the federal court, what is it? What are the main factors, right? So we want very detailed explanations. We want very clear documents. If there are discrepancies, gaps in education, financial situations that need explanation, those have to be providing evidence. So, if a study permit application 2014, 2016 took us a couple of hours, it's a completely different ballgame now. And, I don't want to say it's the same as a permanent residence application, but it really has similar significance, because remember, this is really the gate. If you don't get in, for a lot of people from many countries, if you're not able to come to Canada as a student and sort of start down this path, you're probably never going to have an option for immigration to Canada, right? So there's a lot of significance in my approach for study permit applications to prepare for court. Hopefully you'll get accepted and you won't have to think about that. But if you are not accepted, you want to have the best chance to be able to go and say, this is what I presented, and this is why the decision is unreasonable.
LG, did you want to add something to that question? I have one more thing to say if I can say now.
No, go for it. And then
Just
we'll
soaking in
shift
all
over
this
to
in.
the, no worries.
One
Just
of the Zeynab, your ideas were pretty much all my ideas. The one thing that I'm doing now too, and this is just a new strategy and a tip for the listeners out there, I'm actually creating now 2 applications within one. The one is the judicial review proof application, the one with you said with all the details covering the gaps and everything. And then I'm trying to cover everything in like a covering page or in the first page with like pure summaries, right? Like straight bolded font, point form, tables with finances, just the most simple. If you had 2 minutes to tell me your case, what would you say? Because I think that is also becoming increasingly important, especially if there's pre-assessment officers who, don't want to take the time to read everything. If it's a messy file, they're not going to spend time reading through your page 70 of your translated document. Right?
To add to Will's point, actually, you're right. Actually, my first page, and just like a tip for those who are doing this out there as well, my first page is also an executive summary. It's an abstract and it's got a lot of colors, but it's still very simple that in 5 seconds of looking at it, you'll get the gist, the theory of the case. It's very important now, especially as we are like facing the barrel of the gun of AI down the horizon. It's coming. We need to be smart with this system that is already in front of us.
Yeah, and I want to reiterate Zeynab's point that the forms are just so vastly underappreciated by the clients. And that's often where they're not reviewing what their advisors, or unfortunately it's agents often overseas that are doing. If you put the wrong amount of finances in your form, if you don't lay out the detailed work history, those things are going to come back to you. Even if you have it somewhere in your letters of explanation, in your statement of purpose, you need to include that information in the forms to make sure the officers see it and that it's pushed over to their system. So that's a really good point.
Technical question, do you guys OCR your documents before they're uploaded into the system? I do, so that an officer could presumably do a Control F.
That's a very, very good idea. Very good idea.
Yeah, we have to do that for the federal court now. But I guess one problem with OCRs, though, is it doesn't capture oftentimes foreign languages very carefully. So it can blur the heck out of those. So another discriminatory aspect of it. Last question before we go to Okran. I do want to talk about, again, focusing on the client. How do we break down the myth of judicial review? Because let's be honest here, judicial review is vastly misunderstood. Yeah. I would also say it's vastly not done well by most practitioners. The ones that do it well do it very well, but I've seen a lot of bad judicial reviews as well. And then, a combination of the court delays and things that are outside of applicants' control, especially when they have letter of acceptances that are expiring and terms that need to be deferred, it creates this culture of misunderstanding that are often exploited by agents and consultants and individuals who can't go to federal court saying, your only option is to reapply or apply for reconsideration. So what would you say to someone about the judicial review process if they have a refused study permit? Why should they do it?
Absolutely. And, well, I think, as we've moved forward and there's been more judicial review cases for temporary resident applications, whether TRVs or study permits, et cetera, and that knowledge spreads within communities, that helps a lot. It's always more difficult. And I was more hesitant myself. Like if we were talking in 2019 and somebody was asking me, I would have explained the judicial review process, but I would have probably advised them to try to reapply. But once now, the data is available. So we can rely on the data, providing them with information in terms of, unfortunately, if you are refused, the chance of getting refused again is high. We have applications where we're doing judicial reviews where the person was refused for the 3rd time or the 4th time, right? And there's really nothing else that could be added to the application and it's complete. And so in those circumstances, it's extremely valuable to be able to do judicial review. As I said, thankfully, when people have done this and they're able to go back and explain to their friends and other people that they maybe applied with, that has a positive impact. I know that, for example, within the community that I've been working at, that's actually sort of snowballed, right? So there's actually a lot of applicants from Iran who've been refused for study permits and done judicial review. So there might be lots of applicants from other countries that are also refused, but they haven't had this positive experience of trying to do the judicial review. And it is certainly challenging because it's never guaranteed. We don't know exactly how long it will take. Something might be settled in 20 days and something might take 8 months, 9 months, and there is certainly that concern, and there's the cost aspect of it. But I think because there have been results, there have been good results for a lot of students who've gone down this path. And the reason that there are good results because they were strong applicants who were unfairly refused and unreasonably refused, then I think there's still an opportunity, even with this whole system of Chinook that we're talking about, for people whose strong applications are refused to be able to use judicial review as an opportunity to have their files actually read by someone.
I was actually going to circle back to that point that you made earlier, that it's actually potentially the first time that an officer would seriously consider an application once you JR a refused application. But allow me to shift the conversation a little bit here. Turning now to Okran, actually, the pending litigation before the federal court. I'm just wondering, Zeynab, what do you hope the federal court will do when they hear the department IRCC's argument for Chinook? Basically, the dichotomy between expediency and how do you balance that with privacy, for example?
You know what? I have spent a lot of time over the last several weeks thinking about this. Will and I have talked about this. I've spoken to other lawyers. I've talked to consultants about this. And all the things that, are my concerns have actually sort of, I put them aside because today, and this is the information that I just got a couple of hours ago, I got the respondent's memorandum of argument, further memorandum of argument that was just filed in Okran. I think it was filed yesterday. And I was just dying to read what their argument is. Like, how are they going to try and use, the Chinook system and justify, reasons of using a note generator, etc. And to my complete surprise, there's no real reference to this. There's no argument about this in the notes. It's all with respect to a very fine point, which is the production of the CTR, a certified tribunal record, because the CTR has to be a copy of the full application, including notes, etc. And what it appears the Department of Justice and IRCC are arguing is that, I mentioned really early on that some of those notes, etc., are not copied over into GCMS, and also the fact that there's two systems. So there's these notes in the Excel and they get copied over. So it appears that Department of Justice is making an argument that we're just disclosing this and letting everyone know that the CTR is being presented in this way, but there's no problem with it. And the really interesting thing is nobody in any of these matters has ever come forward and said, we believe there's a problem with the CTR. So I'm not sure exactly where Department of Justice is going to go with this and what they're going to argue, because, all of the concerns that we've just talked about, but it appears this is the way that they've presented it. Now, my concern, I guess, if we're talking about potential ways in which this could be interpreted is, I'm a little concerned that it could come to the point where the federal court could say, it doesn't matter really what the notes are. If the officer decided this is going to be acceptable. And I don't think we're there yet. Thankfully, that's certainly not the argument that's been presented. They've not even gone close to that in their memorandum. And, relying on all the other cases that we've seen, I think from 2020, 2021 in study permit applications, I think that duty to actually provide reasons that are justifiable and that flow is still going to be strong. And I'm just curious why the Department of Justice has done this. One of the only things that I thought might make sense is that they're maybe trying to, set the scene for those questions of AI, et cetera, coming in the future, right? So this is one step closer to, we use extra tools, technological tools to process things, and we might not keep part of the notes. Now it's officers, and later it might be computers, right? So that's possibly where it might be going. But other than that, I'm just like on the edge of my seat, waiting to see what they're going to do.
I said, for those interested, Okran's coming up in 2 weeks, and hearings are publicly viewable. So if you want more on this drama, I think we should all go watch Okran and see what they do and take notes.
A Netflix watch party, right? Federal court watch party.
I'll bring the popcorn. But Actually, while you were talking about what the overall strategy is, a lot of alarm bells like ringing in my background. I'm thinking when you were talking about logical flow, I mean, that really goes back to what was handed down in Vavilov, where logical coherence and reasons have to be logically explained. And to me, this really comes into question when I think about how officers are essentially trying to lay down their reasons. They may not have laid out the argument in this responding memorandum, but then it begs the question, because I understand that the DOJ may be trying to introduce the same affidavit across different litigate. From what I heard from the intro, this is the second time that you may have encountered this, and I heard that others have encountered the appearance of Chinook in TR applications. I'm wondering if this argument their actual argument has been mounted somewhere to sort of like create that baseline case to sort of divert from current, underpinnings of procedure, essentially having reasons that are logical and coherent.
It might be working towards that. And Lou, I honestly would have thought that this might be presented in a different way. I'm quite surprised. As I said, I just finished reading this before we got on this session. So I haven't really had a chance to process it and think it through that much. And there's a very clear focus on the argument they presented that it's all about the CTR, and we want to make sure that the CTR, and it's a courtesy to the court that we're providing this information when, like, literally no one has asked, and they have filed this affidavit across the board. Like I don't want to say in every file that we have, but in so many of the files that we have, wills files, they're putting a lot of effort into this. Is it just the CTR issue?
Well, I have some thoughts on this. And again, I think we're all speculating, but speculating is fun. First of all, why shift from one case to another if it's just, an issue there? You deal with it at the initial outset with the memo you had. The other one is they're filing this pre-leave in early stages. They're saying they're going to file this. This is before the CTR even becomes relevant. If leave is not granted, there's no CTR even produced. So that's another flag for me. So I agree with you, Zeynab. Here's my thought, and here's my theory. I agree with you, Zeynab. I think this is on the pathway of normalization. They're trying to normalize and introduce this language and introduce this process. And they found a case maybe where they thought they could pound this affidavit through without many questions. Maybe they too were taken aback by the fact that it was actually cross-examined. And the cross-examination did reveal things that if you actually wanted to make a deal of it, there are deals to be made, right? This is not applied consistently, that they don't have a lot of these stats, that, why are you even filing this affidavit in a case like this? So when you don't want to make it, part of the argument, but you are trying to say it's part of the argument for all your other case, there are a lot of questions out there, but I think I agree with you that they're trying to get this language into the judge's purview to prepare for the idea that we're going to have systems decide cases, not necessarily the human use, the person behind the scenes gathering all the pros and cons and deciding a final decision. It's not going to work that way.
Does it bother the both of you, any of you, really, that the officers' working notes are erased?
It bothers me tremendously, right? And I actually have a concern. I'm like, we didn't hear any information in terms of how how the decision for each person is copied over. So imagine, like, if I'm working in a spreadsheet of 100 files, right? I could easily make a mistake and copy file 45 into file 46, right? And there's no information there's no way to flag that was an incorrect thing, right? Like an incorrect copy and paste. There's just no accountability. And I find that hugely problematic. And I'm just curious why they did this, because it opens up so many more questions for us than it answers, for sure. And I think, you guys mentioned that right at the beginning, but it creates more of,
something along the lines of
more questions.
Yeah.
Puts more questions rather than answers. What are they trying to do? I think that was the theory behind this.
I think we can another question that arises that's really important too is the question of procedural fairness, right? So, you are seeing more misrepresentation findings, and I'm not getting from the affidavit what if it's the working notes before a final decision, if it's an interim, procedural fairness, what gets pushed over to GCMS, what gets maintained, what gets deleted and removed afterwards, right?
There's no trace, Will. There's no trace. That's the thing.
Right?
And Vavilov demands that the logical coherence need to be established. And if you don't have those notes, you can't. And to me, what really is alarming in this whole package of information is that I agree with you, Will. It's sort of like, nothing to see here, very blasé. Even in the cross-examination document, they're trying to normalize it. These notes are being erased, and that it's okay to pick a reason from this drop-down menu on their Excel sheet, and it should be fine, and the court should pay no heed.
Mm-hmm. And remember this, I didn't get a chance to touch upon this, but this tool was developed by a series of, I guess, more technical people in their team, without really input from a legal side, right? I mean, they said maybe they ran some things by the legal, but they did not go back and think about procedural fairness, right? And, I think that comes through very clearly in the kind of conversation we're having today, because they could have developed a tool that considered procedural fairness, right? Like you could create a tool in Excel that generates individual files. Like, I'm not a very techy person, but I can imagine that it would take maybe a little bit more work, but there could be an opportunity to do that, right? So you could have efficiency, but still preserve the idea of having oversight and having that logic that we're talking about.
Okay, so maybe we'll transition to, we're heading close to the final question, but the second last question I wanted to ask you was, what do you think about the Department of Justice's approach generally on these judicial reviews? Because we are seeing in many of these cases clearly, unreasonable decisions created by Chinook, not created by Chinook, just in terms of just the wording. Department of Justice is trying to fight back, reverse engineer, right? Saying that, there was insufficient evidence, there could have been all these explanations that weren't provided, nothing that's actually in the actual officer's reasoning. Mm-hmm. But then, it's causing our clients to have to go through like you said earlier, an expensive, drawn out, spend months and months fighting until a leave decision is granted, and then suddenly the tent is being folded, consents are occurring. Mm-hmm. These cases never make it to, a lot of them never make it to court, probably because our positions are so strong as applicants. What do you think about this strategy, though, of bringing students in? And what is the fear then if decisions do get sent back to visa offices, and let's say they refuse them again, and they find something else in their list of 100 refusal reasons, and pick on those clients who chose judicial review as a process?
Yeah.
Is that something that concerns you?
I think that there's a recognition within the IRCC system that there are a large number of errors, right? I think that they recognize this at the visa office level. They just don't have the resources to be able to deal with it. I think they recognize it for the most part at the judicial review level too, like when we're dealing with DOJ. We actually have had a lot of files that have been consented to and settled prior to hearing decisions. I know that you've had a lot of files where after you get to the leave decision, then you've received settlement. I think that's a little bit more difficult for applicants. It's a delay, right? And their whole goal is to come steady. But I think that recognition of the errors makes it much more likely that when somebody goes through this process and their application is reopened, for the most part, I've seen that they've been accepted. And I think the reason for that is that I don't know what they do, but it's not going back into the Chinook system. It's not going back into this, like, got to be processed really quickly. I think somebody sits down in the local visa office or the automobile visa office, wherever it is, and will review the update documents. I have seen a couple of files that were refused after resubmission. And in those files, it's interesting because you don't get Chinook style generic reasons. You get somebody who sat down, reviewed the documents in full, provided complete sentences with a logical flow. So you can't JR it for sure, but it makes sense, right? So they've actually sat down, they reviewed it. They said, there's an error, there's a problem, there's a real concern with respect to certain aspect of the application, which is what we would expect should happen in every single application, right? So at least in my experience over the past year and a half, there's that recognition. Unfortunately, I think there's not a completely unified approach across the DOJ in terms of how counsel should react to these files. I think they're probably overwhelmed too, just with the sheer volume of these applications coming in compared to previous years, and they're overworked too. Some of the DOJ lawyers are much receptive to those conversations about settlement earlier on in the process, and some of them will, in fact, try to justify those Chinook reasons and notes, and those files may go to hearing or a leave decision. Yeah.
Unfortunately, in Vancouver, we don't even have the early settlement pilots that you have. So in our cases, oftentimes, unless you are able to connect with counsel in advance, that's usually not assigned until after you file your materials. It's difficult to start that conversation.
Mm-hmm.
And I agree with you. I think if the ball is always in Department of Justice courts to determine what gets filtered up, what gets to go to court, and oftentimes it is, unfortunately, bad fact cases that go to court.
Yeah.
Bad facts make bad law. There should be a little bit more, I would say, on the front end to allow us to resolve our clients' cases without having to drag them through the laundry cleaners all the way to the end, and then their lives in 5, 6, 7 months can be disrupted through this process.
I'd like to circle back to Zeynab's point about expediency and balancing the cost of the whole system as well. I mean, to her point, is it actually even more efficient for the taxpayer to keep on litigating files that involve study permits? When I first explained the study permit judicial review process to some of my clients, they were shocked. Their jaws literally dropped, because in other countries, for example, in the US or in the UK, they would just get an interview. And all of these doubts that, visa officers would basically have issues with, let's say at local visa offices or in Ottawa, would be dispelled. They would be able to address and make follow-up questions right there and then. They can easily make those decisions just by looking at the person, because if their application isn't consistent, then it's easy to establish that. Whereas we're now dealing with a system that prioritizes expediency and low costs. And as Zeynab said, there are clients who are willing to actually shell out more than the $150 for those study permit applications, in view of the fact that they will be spending thousands, tens of thousands of dollars when they get to Canada anyway.
Lou, I couldn't agree with you more. I'm actually quite in favor of an interview process being added, or having a more transparent system where we, again, the study permit stream is a way in which applicants can create much more long-term plans. And if we are allowing people to come as students, we could be more transparent in terms of, opportunities that people are going to have later to apply for permanent residency. So if you really, I think sometimes an officer will look at an application, they will not say it, but they will probably decide this person has no chance to really apply for CEC or federal skilled worker later. So they would, after their studies, they might stay illegally, right? Or they might overstay, etc. And so they're doing this calculation. Why don't we make something like that a lot more clear? Like the government of Canada could come out and IRCC could make the requirements much more clear. And, all of those implied biases that the officers have when they're assessing these applications, if applicants know that up front, then we won't have, someone who has a diploma at 35 applying for a bachelor degree in Canada, right? Like, if you don't know that this is a calculation that's going on in the officer's mind, you think, okay, if I have the resources, I have this, I have that, I can apply. And for Canada, it's just $150 processing fee. But for that person, it's potentially hundreds of dollars of other fees in terms of getting admission, etc. And I think that might make better pool of applicants in terms of, ultimately what Canada does when it goes around the world and it markets itself as a study destination is, we have postgraduate work permits and you can apply for permanent residency in the future, right? So if we're being very honest and transparent about it, there are ways in which the government can actually create much more clear guidelines and can have slightly higher fees, can have interviews, so that we have this whole system in place that creates a more fair opportunity for people to have their applications assessed.
I know we don't have time for this on this episode, but we probably want Zeynab back for another one on this. But the whole education industry, I know there's the recent Walrus piece, but the billions of dollars that are being funneled now, the new things with students who are overseas studying online. I know that I've had so many consultations on that where they've been online, they've paid their Canadian tuition, or they've got their first stage approval and then they get refused later. They just can't get study permits, and yet they've paid all this international tuition money to Canadian institutions, paid their agents a lot of money to get them into the schools. So there's definitely something that's more systemic here that we need to focus on. And I think Zeynab's comments are definitely one part of that to improving the system.
Zeynab, please come back.
Yes.
I would love to, guys. Yeah.
So on that note, I think our final commentary that we just want Zeynab to discuss, and I think that's actually a perfect segue, is the power of collaboration. And I know we wanted to end it on a more positive note, given we kind of went through a bit of a critique system session over here. But, for me, Zeynab, this has been a power of collaboration, you collaborating with me on this, and then us trying to collaborate with OCRIN's counsel, who I think have been pretty receptive to us as well. And then LJ with all the evidence and data that he provides us, and I think that has been circulating through different institutions and different clients and has really made things more transparent. How do you think we can collaborate better as immigration representatives, as lawyers, as consultants, as those who are holding our students' interests at the foremost moving forward? What can we do?
It has been such an interesting and inspiring experience for me as well, being involved in this whole process. And it's funny because, it's the pandemic and we're literally in different cities, but we're able to collaborate. And I think at the seed of this is some of the work that I've seen at least will do in terms of raising awareness, right? And that kind of selfless information sharing, like when you learned about OCRIN, it was, let's get articles out there, let's get awareness out there, let's allow other practitioners, lawyers, etc., to learn about this. It was fascinating. I was actually talking to an immigration consultant today, and then he started asking me about OCRIN, and he's like, I saw that you were involved in this, and I was like, this is great. This means that through all of these channels that Lou, etc., are on, this information is getting pushed out there. And I think that overall collaborative approach, I think all of us within this industry want to have a system that works efficiently, that works more fairly. And we're literally all on the same team, right? We don't want fraud. We are all fighting for the same main principles here. And I think part of the first part of that is the information. So I think, because of that information, I was actually able to connect with Will on this. And then I think it's an amazing community that we can rely on each other, right? So I think we've done this on a pro bono basis, working on, assisting on the OCRIN case. And I'm happy to put in more time as necessary as issues like this come up. And I think a lot of our colleagues are too, and that's what makes it a great community to be able to continue to work in.
Wonderful.
Well, on that note, Zeynab, thank you. And please, please, please come back. We would love to have another discussion with you on a bunch of other topics concerning study permits.
Absolutely. It has been a pleasure talking with you guys today. This has been something that I've spent a lot of time on. We're working in the trenches every day, getting these applications out, but, having an opportunity to discuss it has been great. And I hope that it will be helpful for our colleagues and to your listeners as well.
Okay, well, that was very, very much enlightening. I learned a lot. Final thoughts.
Yeah, well, Zeynab has been spending a lot of time thinking about Chinook, thinking about OCRIN. And my final thoughts are for all of us as counsel and for applicants themselves to do a lot of deep thinking on these systems, on the way we want our immigration system to go, because we know artificial intelligence, we know machine-based learning. These are things that are going to become common. These are things that society is working towards, not only just immigration. But as we dehumanize these processes, what happens to the applicants at the heart of this? What are their expectations? What are their procedural fairness rights? If we create a more transparent system, and if we let more individuals know about how these systems work, at least people can make an informed decision about whether or not to spend or invest in Canada. And that way we also tackle fraud and tackle all those things, these outside considerations that often sway students the wrong way and can have a huge financial and mental health impact on them. So, you know what? it's just the start of the conversation. We're just starting to learn more, but I think this is, again, for me, it's the most important development of immigration probably this year.
I agree. And I really don't have final thoughts on this. I think I'll just echo what you said, but I do have a few things to say on closing. First of all, I want to circle back to our point about collaboration and the power of working together across the bar, even in the midst of a pandemic. Physically, yes, we are disconnected, but I just like Zeynab, I feel more connected to the immigration bar, getting lots of colleagues cross-generational in the immigration refugee bar. This is all fascinating and I'm learning a lot. And I'd like to also highlight a point. It's essentially a call to action. Will has started this thing called Operation Catch the Chinook. Please contact Will. He has prepared a cloud-based Excel sheet, in fact, to catch the Chinook. Yeah, exactly.
Module 4.5.
4.5, exactly. And we're just trying to figure out if we can find some similarities with respect to the refusal notes. So please, please, please get in touch. Yeah. And finally, I'd also like to do a little plug for Will. He has a talk coming up, I believe in October. Is that
it's in October? It's
right.
It's virtually, but through Ottawa, correct?
Fantastic. And I myself also am doing a little bit of a plug in November. If things hold up, I think hopefully it'll be in person in Montreal for the annual conference for Acadie. But we'll see. I mean, it could revert to online. It really depends on the epidemiology in the coming months.
Great. Well, as the summer rolls by and, we went from spring to summer, the seasons changed now to fall. We want to thank all our listeners for being a part of this journey. We would love to hear from you. So please add us, contact our socials, email us. Subscribe. Let us know what you want to see. Subscribe, hit the like button. Let us know what you'd like to see. We're a relatively homegrown process. We bring on guests that usually wouldn't be on other shows. We find individuals. One of our guests has recently gotten, a huge job with a national media company. We find people before they go big. That's our thing.
Bellwether.
So, whether you're a sponsor looking to support a grassroots project, or if you're a listener or an immigrant who's experienced something and want a voice on our show, please reach out. We're always looking for new content. We look forward to building an amazing fall for all of you.
On that note, thank you very much for joining us in today's episodes, and we will catch you in the next.
Take care.
Bye.